Krystle, we have an issue. Someone left the band. Now they're using the music, but they have ownership, but we kicked them out. What do we do?
Yeah, I feel like we've done lives where we played our own music and
we got shut down. That's really what it is, right? I'm like, we fight the good fight. We get your money back. We get your music reinstated.
This was on the TuneCore Exposed video that we had. If you had anything to say about anyone who continued to use TuneCore after your videos, what would you say to them?
So anyone watching right now, which might be TuneCore. Someone said that once. They're like, I think TuneCore watches all your videos.
They've seen a few. I mean, they won't see the ones that say TuneCore Exposed.
That's right. So for anyone watching, anytime I've commented on TuneCore in regards to the dispute with my client, in regards to us just kind of putting forth our interpretation of their terms of service, for example, that's one thing. Whatever you take away from that is on you. But you know what? Someone who was with TuneCore, just meeting a subscriber, a user, left a comment, and I responded to him because he goes, "I've been with TuneCore for 2 years, and you're saying all this stuff. It kind of sounds like maybe your client did do some bad things. I don't know, but I've had a great experience with them." And I responded to that guy. I'm like, I appreciate your input because it's great. That's been your experience. And that was what I said. I'm like, it's not so much that, like, with these companies, I go, if the terms of service, the contract that you are forced to sign that you typically won't even read, you don't even know what you are allowing them to do. If the contract says this stuff and my interpretation is that it is unlawful, I'm going to let you guys know about it. It doesn't mean that bad things are going to happen to you. And so, my call to action, I was like, in my first video, I go, I'm not here to, call TuneCore just a terrible company, and I'm not telling you guys to leave their platform or anything like that, because a lot of you might have had a great experience. This only becomes a problem when they're like, hey, FYI, we forfeited your royalties and you can't get them now. So anyway, to hopefully answer that question a little more clearly, if you're having a great experience with a certain company, I'm happy for you.
Right.
Just, be informed.
What if I don't make money off the music I used or sampled?
Yeah, so common myth, if I use someone else's song without authorization, but I don't make any money from it, and I've even seen this on stuff people will post, and they'll be like, this is, not for sale, this is not for commercial purposes. It technically is. It doesn't matter, and that's why we talk about statutory damages for copyright infringement. And I'm like, homie, I don't care if you made $1 or you made no dollars. Pursuant to the law, if the person has a properly, registered copyright, they did it in the right timing, all these things, they can actually sue you for up to $150,000 per instance of infringement. So it's actually a huge deal. And just because you're like, you make it, a note and you go, I'm giving credit to the original author, I didn't make money on this, like all kinds of things that people do to try to,
they put
lessen the potential issue.
Copyright infringement intended. They'll put that on their videos when they're doing stuff, no harm meant or whatever. And you see that all the time. So let's say you took sampled 3 different parts of songs. That song that you didn't make any money, it just cost you a whole lot. My previous band still plays songs that I composed, arranged, and recorded. What is being infringed?
Yeah, so with bands, usually I hear from you guys for 2 reasons. One, and this is a rarity, and it's like, hey, we're starting a new band, we want to make sure we have an agreement, and we want to start an LLC, like all this stuff. It's so rare. That's actually what you're supposed to do every time. Or the second situation, which is, Krystle, we have an issue. Someone left the band. Now they're using the music, or they're saying that they have ownership, but we kicked them out. What do we do? And so now we're trying to reverse engineer the situation. So to answer your question, it just depends who contributed. Because remember, the whole work for hire, the reason we do that is because in a band situation, you guys are a little family and you're all putting in to make the music. Yeah. And everyone who puts in creatively to make the music has copyright ownership in it, regardless of what you said, regardless of what you agreed to, unless you actually put it in a writing and you go, this is intended just for John and Jane, or this is intended just for our LLC that we set up on behalf of the band. So the problem can be person leaves and now we're unclear on the ownership, problems break out. And so really, we jump in just to try to mediate as step one. Yes, we can threaten and all those kinds of things, but we just try to work it out and be like,
this is something that bands do not do at all. They don't even think to do this until later on. I've seen other bands I want to say Train, and just because I've heard them on the radio talking about their situations of just when they've lost band members and been in lawsuits later on. You need to have these agreements in place and what's going to happen. And most importantly, who has the right to control the release of music, who's responsible for it. You need to have all those conversations when you're starting a band. Your band is your business.
And then just a pro tip, if someone's watching and they're in a band, you want to set up an LLC, and then you want to get what's called an operating agreement, which all the members of the band who are in the LLC who have ownership will sign. It's like the rules of the road of who gets to pay for what, who gets to, get what income. So that's what you need to do.
Make sure that you guys are subbed up. We did hit that 40K, and we are super stoked about it. This is super awesome. You guys as a community, your questions and your energy has just been awesome. So I have a question. If Spotify flagged one of your songs for fake streams, but I absolutely know that's not true, do I go and fight them or just reload the song back onto Spotify? I don't understand.
Yeah, so it's not that you're reloading them onto Spotify, right? You have to ask your distributor to redistribute them or re-enable them, or if you take them down and you just redistribute them through someone else. There's lots of ways to kind of go at that, but if it was flagged and taken down for fake streams, it's really just cost benefit analysis, because we've talked about there are clients who will come and hire our law firm to enable communication. That's really what it is, right? I'm like, we fight the good fight. We get your money back. We get your music reinstated. These are things that we strive to do and typically accomplish. But really, the reason why you're reaching out to us is because these platforms stopped responding to you. And all of a sudden, they take us more seriously because we're lawyers and we're going to,
right,
burn them down with letters and all kinds of things. So in any case, it's really just a cost-benefit analysis of how long you fight, what you fight for, why you're doing it, and if you pay someone else to help.
Question. If I hire your law firm to help me get a trademark for my artist name, will you own the trademark or will I?
Oh, yeah. Shoot, who am I, TuneCore? Yeah, just release through me and I'll own your artist name. Shoot, I need to rethink my whole business model. No, if you hire a law firm, including mine, the law firm should help you to file, to put together your application, because you want to do this at the federal level. So each of us in the United States, we can file in the state we live to get a trademark at the state level. But what you want to do is get it nationally, all throughout the United States. So that way, if anyone else pops up, you can deal with them. So either way, if you're getting someone to help you, they should just be putting it together, filing for you, responding to what we call office actions, responding to the letters that the trademark office will send, being like, here are the problems. That's what should be happening. No one should be taking ownership in your trademark or artist name at any point other than you. Become your own record label, which is literally, if you're like, hey, I want to start a record label. Cool, I got you. Understand the entire music business. I want to set up my LLC. I want to do the marketing. It's a lot. So for example, sync licensing, for example, music marketing, it's significantly cheaper than anything you would ever get from a law firm as far as all the stuff that comes with it. And you want to make 6 figures from your music career and you want to do this for real, like, I'm going to give you what you need.
Is it necessary to do a work for hire document with each person I hire who has helped in the development of a cover song, like a sound engineer, backup vocalist, etc.?
Yes and yes and yes. So I actually did this for one of my clients today. So just building a work for hire and just making it super simple. You should just have a template that you use. And so everyone that you work with, everyone that touches your music in any kind of way should really sign it, because anyone who has helped you in some kind of way could technically make a claim if they're like, I was the one that mixed your song, or I added that in that little guitar shing. Literally, it could be that minimal, and someone may have a claim for copyright ownership in your song, and you didn't even know it, pursuant to copyright law. So what I always want you guys to remember is that if you are hiring someone for any reason, a website designer, a graphic designer, a staff person to help you with things, you want to have a work for hire that has confidentiality in it, right? But also has assignment of ownership, and just to be like, look, to the extent you might have a claim in something we made together, this is what it is. I'm paying you some money. You own nothing. I own everything.
Right.
I think I have a template for you guys because it's so plug and play. You just, if you have the right template, you just put in the right names, you put in the amount of money and define what's going on, stuff like that. And there should be a template on topmusicattorney.com. So if you need one of those, go check it out. It's DIY video. I do it all for you.
What if you record a song in a studio and pay the engineers to mix the song, etc.? They have claim in the song?
I've kind of disputed this with some people because they go, well, what creative thing is the mixing engineer doing? And I go, well, it just depends, right? So we've had mixers who we've been like, hey, if you have a little idea for this or a little idea for that, you can add it. So if they're doing exactly nothing
some have just
creatively,
taken liberty.
Yeah, and so, I think that's maybe more clear, but someone else might argue and just say, well, them coming in with that audio design,
right,
that is a creative contribution, creative decision making, and so they may have a claim in copyright of the song. And so it's not totally clear, which is why I always go back to someone who does something for your stuff. If they're not supposed to have any kind of ownership and you're just paying them money, make sure that's clear. Just put it in a quick writing. It's I promise.
Like, anybody that you're working with that's professional is used to these contracts. So it's not like you're, hey, and they've never seen anything like this before. Like if you're going to studios and you're going to like, they deal with this all the time. If someone plays my song, which is uploaded on TuneCore or any other DSP on an IG Live or YouTube with my permission, would they still get copyright flag on their live?
Yeah, so typically with Content ID, depending on if you've opted in.
Yeah, I feel like we've done lives where we played our own music and
we got shut down.
So, yeah, I would say yes, they could, because that's happened. That's happened to me. So
yeah.
I'm like, no, we're all good to use that. As an artist who just started uploading YouTube, what steps would you recommend?
Yeah, so I think some artists who aren't sure that they want to release music on music platforms and they're testing stuff out, they're trying new genres of music. I call YouTube or SoundCloud or TikTok soft release platforms. So you can try stuff. And so I would just, recommend maybe using it for that purpose. However, huge caveat, it is extremely difficult to get subscribers on YouTube, to get views on YouTube, to get into the YouTube algorithm. It is like one of the toughest platforms, which is also why we're just so grateful because we have 40K today, and we're just want to make sure to celebrate that all throughout this live stream. But as far as just being like, if low views are going to impact you in any kind of way, probably don't use YouTube as your main thing. But setting that aside,
drive traffic
just,
on your social media.
Understand there's just mad content ID on YouTube, so you're sampling, your cover songs, all that stuff that we talk about on this channel. Make sure you're doing it right, because your stuff's going to get monetized, or you'll get strikes, or all kinds of things. But other than that, go with it, baby. Release your stuff. I'm licensed manager in Alabama. I've represented from Chicago State licensing. Yeah, so for agents, guys, this is something that comes up. So remember, I do music, but my law firm is entertainment in general. So we do business and IP, intellectual property, stuff like that. So when we work with specifically managers and agents, you just have to be aware of your state's laws. So like, for example, in California, it is impermissible. It is against the law to be a manager and an agent, because technically the agent takes money and has like fiduciary responsibilities. Manager doesn't. Manager is in charge of day-to-day stuff. And so in California, they go, absolutely not. You can't be doing both roles. But in Arizona, for example, it's totally fine. So I would just say, depending on where you reside and the applicable law in the contract for the agent services or manager services or whatever, that's how you will need to think through this on, what you need to do.